Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of the stories covered in this month's update, don't forget to download our News In document using the link shown on your screen now. The famous Hadley v Baxendale 1854 case determined that there are two types of losses: direct losses that arise in the ordinary course of things, and indirect or consequential losses, losses that arise from the circumstances. There has been considerable interpretation of what's included in these categories over the years, but a recent case has reiterated that the court now adopts a more literal approach to the words in the contract. The contract in this case, that concerned a ship engine that had failed, excluded consequential losses, damages or expenses. Here the court decided it was clear that the contract excluded all consequential losses. The ship owner could recover the cost of a replacement engine and the repair costs of physical damage, but nothing else. The case of First Group plc v Pawley had its twists and turns in 2016 as it made its way through to the Supreme Court. In this case, Mr Pawley, a wheelchair user, had not been able to board a bus after a mother and child who occupied the wheelchair space refused to move. The Supreme Court determined that First Group does not need to require a non-disabled person to move in a similar situation, but must at least consider measures to pressurise the non-disabled person to move. A recent case has given some helpful guidance on how far liability may extend under the Misrepresentation Act. The case involved the sale of loan notes by Party A to Party B, who then sold on to Party C. This was followed by a claim under Section 2(1) of the Act. However, the claim had challenges as the misrepresentations that Party C were relying on were not made by its contracting party and were contained in a presentation that included some standard disclaimers. The Court of Appeal decided that the disclaimer was valid. Now, disclaimers must normally be by agreement, but here the disclaimer was in the same presentation that contained the misrepresentation, and Party C was an experienced professional investor. The Court of Appeal was also clear that Section 2(1) of the Act only made a representor liable to its contracting parties. There have been two noteworthy prosecutions by the ICO in the last few weeks, including a £40,000 fine against a company that made marketing calls to people who had registered on the TPS list, and a £150,000 fine to the Royal Sun Alliance, that's the RSA, after a device containing customer details was stolen by a staff member. RSA was criticised because it did not have restrictions to its server room, the device was not encrypted, and the RSA did not routinely monitor its equipment. With the implementation of GDPR looming closer, the ICO has published updated guidance on its website, including an overview of the GDPR and 12 preparation steps to take now. In addition, the Commission has announced that it plans to implement replacement regulations for the existing privacy and electronic communication regulations in 2018. The regulations are principally there to govern electronic marketing, for example text marketing and cookie notices. It's expected that the new regulations will require more transparency to tackle concerns that cookies are used surreptitiously to monitor consumer web usage. Another month and another gig economy case, this time Dewhurst v City Sprint. Like Uber, the tribunal was not interested in the words in the contract, but what was actually happening. It found that City Sprint exercised a high degree of control over the individuals it engaged with, and therefore they were workers and not self-employed. This is now a turbulent area of the law. The Deliveroo case is ongoing and Uber is being appealed. Meanwhile, the government is conducting a number of reviews looking at different aspects of worker rights. Rolls-Royce has agreed a deferred prosecution agreement which includes a payment of £497 million. Like so many other bribery cases, the use of agents was central to this case. Concerns identified included the provision of lavish MBA programs to Chinese officials and expensive gifts. One interesting email was unearthed in the e-disclosure process from a Rolls-Royce employee that stated, "I told the Rolls-Royce employee in Russia on Monday I do not want to see any of this stuff appearing in an email in the future. If he does it again, I'll bring him back to London so we can give him a face-to-face scrubbing." Thank you for tuning in for this month's commercial bulletin. For more information on any of the stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in March with more of the month's key legal updates.